Greetings, everyone. My name is Breon Cummings, and I am the O'Donnell Consent Decree Project Manager. And so today is our third public meeting, so welcome. Per the O'Donnell Consent Decree, Section 10, Oversight and Accountability, all parties recognize that the input and involvement of the residents of Harris County will be essential to meaningful and lasting reform and to effective and ongoing monitoring and evaluation of the system. We are all committed in involving community members in the implementation and monitoring process. The Justice Administration will host semi-annual meetings virtually until further notice. We began in October 2020, and this is our third public meeting. So welcome, everyone. We have some agenda items. We can go to the next slide that we're going to address and questions. And so as the presenters are presenting, please feel free to ask questions in our question and answer section. We may not answer them immediately, but after the meeting or at the conclusion of the meeting, then we will go through the question and answers and try to answer all of the questions posed to us. So just list it in the question and answer section. So today's agenda is the following. First, we're going to have a welcome by the Interim Director of the Justice Administration. Next, we're going to have an overview of Harris County safety and justice goals and the purpose of the Justice Administration by myself. And then we'll have progress updates from the following parties: the Federal Court Monitor, the Federal Community Working Group Overseer, our monitor, the County Attorney's Office, the Sheriff's Office, and the Criminal Courts at Law. And then we'll have question and answers at the end. All right, let's introduce Dr. Anna. She's our Interim Director of JAD. She serves as Interim Director of the Justice Administration. She's joined JAD in June of 2020 as Deputy Director. In this role, she helped manage a team of talented professionals, assisted the director in developing and implementing the department's strategic direction, maintain and manage relationships with internal and external stakeholders, and helped oversee public education, outreach, and policy research efforts. Anna will continue to be a key leader in addressing the many challenges and opportunities in our criminal justice system as interim. I'll turn it over for a warm welcome from Dr. Anna.
Thank you, Bree, and thank you for all of the incredible work that you have put in, and more importantly, to all of the panelists. I am so grateful to each and every single one of you for participating, for sharing your expertise, your knowledge about the importance of the Consent O'Donnell implementation, and for all 88 of you who have logged in during today so that we can learn about where we are and what we need to do to move forward. We at the Justice Administration Department are committed to hearing your voices and to partnering with all of you. So if you have any questions, any ideas, we are all ears, and we are looking forward to hearing from all of you. Have a wonderful rest of the day.
Thank you so much, Dr. Anna. Let's go over some of the missions of Harris County. So overall, Harris County's mission is to build a more dynamic, vibrant, and resilient community with being inclusive, equitable, and transparent in all that we do. Specifically, the safety and justice goal. Harris County will promote safe, healthy, thriving communities through restorative and evidence-based strategies that foster public trust, prevent violence and trauma, reduce racial and economic disparities, and minimize criminal justice system exposure where at all possible. And so the Justice Administration is part of that. And so why this department was formed, because we're an independent research department, a part of Harris County, working collaboratively with the Commissioner's Court and criminal justice stakeholders to help them fulfill the vision for the county, specifically by advancing innovative approaches to justice that are consistent with Harris County's justice and safety goals that we just discussed. So let's talk about the conception of the consent decree. So May 16th, 2016, Miranda O'Donnell and other plaintiffs brought forth a federal class action lawsuit challenging the Harris County misdemeanor bail system. Before the suit was settled, the criminal courts at law decided that they wanted to amend the local Rule 6, and that was done at that time. On November 21st, 2019, Commissioner's Court approved the O'Donnell consent decree. December 9th, the County Attorney's Office publicly solicited proposal for an independent monitor. In the midst of soliciting for that monitor, on February 4th, we started the Cite and Release program. And then on February 19th, 2020, the Justice Administration launched the consent decree website, which is still present to that day, to this day. And so we'll give you all of the information on the end. It talks about all of the litigation. It will give you all of the new rules and the responsibility of Harris County. And so we'll have all that information for you at the conclusion of this presentation. On March 3rd, Judge Lee H. Rosenthal appointed independent monitor Brandon Garrett and deputy monitor Sandra Guerrero Thompson. On May 2nd, 2020, JAD summarized and posted key policy changes in JPC and CJC. So if you're in those buildings, you should be able to see those policies posted within the hallways and in the lobbies of each of those buildings. On May 8th, 2020, the monitors established a community working group to share their findings and solicit feedback on the implementation of the consent decree. So as you can tell, from the conception until now, there has been a lot of work that has been done in Harris County to assure that we are in compliance with the consent decree. And so next up, what I'll do is I'll hand it over to our federal monitor. Every March and September until 2023, and every September thereafter, the monitor is required to conduct a review and write a report in regards to Harris County's compliance with the requirements of the consent decree. Next up is Professor Brandon Garrett to elaborate on the report submitted to court on September 3rd, 2021. Thank you, and here's Professor Garrett.
Thanks so much, Bree, and thanks so much, Dr. Reyna. Thank you all for participating today. Professor Thompson is here with me, and we're going to together describe the last 6 months of our work. Like Breon Cummings summarized, our work has now been ongoing for a year and a half, and so this is the third time that we're sharing our work and results with you all. And there are many more public meetings to come. Our job is to supervise the implementation of this real landmark consent decree for a total of 7 years. And so our appointment is lengthy, and there's certainly ongoing work that will remain ongoing for some time. We wanted to give you a status report and describe our role, the implementation that has been ongoing, and some of our findings. So those are the three main things that we wanted to talk to you about. To begin by reintroducing or introducing, if you're joining us for the first time, our role and our team, I'm going to turn things over to Sandy.
Hi, everyone. Again, I'm Sandra Guerra Thompson. I'm a professor at the University of Houston Law Center. I want to talk a little bit about the monitor team and our role. You see our photographs there. So we were appointed, as Ms. Cummings said, by Federal Judge Lee Rosenthal to serve as independent monitors for the misdemeanor consent decree in the O'Donnell case. Our sole job here is to report to the federal judge. We were appointed after the prior system of misdemeanor bail was found unconstitutional for discriminating against people who were unable to pay for their release. This was after years of litigation, which we took no part in. The plaintiffs who sued the county and the representatives for the county settled the case and signed an agreement. This is called a federal court consent decree, and it's a lengthy and involved document in which Harris County officials agreed to make many, many improvements to the way that the misdemeanor bail system works and the overall court system as well. Thus, our role is to oversee the implementation of the new rules, programs, and protocols that cover a wide range of issues. We're not involved in any aspect of the felony bail system, nor do we play a role in the pending lawsuit over the felony system. Again, our role is solely to provide the federal judge with updates and data analyses in a fair and complete manner. Professor Garrett and I are part of a team of researchers including data scientists from Duke University and from the Public Policy Research Institute at Texas A&M University. I see my colleague, Dr. Dottie Carmichael, on this call. And at Duke University, we have Dr. Songmin Kang, who heads up much of the research there as well. Professor Garrett will speak more about the work that our data scientist team has been doing. For my part, I want to discuss the diverse group of community leaders that I oversee as part of the process of monitoring Harris County's work. This is a diverse group of community leaders who advise the monitor team. They include local law enforcement leadership, civil rights leaders, advocates for immigrants and survivors of domestic violence, advocates for foster children, the homeless, mentally ill, veterans, and women involved in the sex trade, as well as representatives of the downtown business community. We're very fortunate to have this amazing group of people working with us to advise us and advance our understanding about many of the important topics that relate to the misdemeanor bail system, which is the largest part of the criminal justice system. Most people arrested in Harris County are arrested for lower level offenses. So some of the many important topics that we have discussed with our community leaders include how to protect survivors of domestic violence, providing access to services for the vulnerable individuals who go through the court system, including especially the mentally ill and the homeless, ensuring that a person's immigration status, which is a separate federal legal issue, does not result in harsher criminal punishment in Harris County. Providing adequate pretrial supervision for people who are released before their trial, and many more topics that the community working group will be tackling in the future. We're pleased to be working with representatives from the Harris County Attorney's Office, the Harris County Sheriff's Office, the District Attorney's Office, the Justice Administration Department, and the County Criminal Courts at Law, as well as their staff. Through our work with all of these county officials, we've made a lot of improvements in how the Harris County misdemeanor bail system is working. We have, for example, overseeing the process of translating forms that people receive to other languages so that they understand their legal obligations and the process involved. We've also witnessed Harris County officials implementing an incredible electronic court notification system that will help people to come back to court and know when they're supposed to be in court and where. And many, many other similar kinds of improvements in how the courts operate, the implementation of having public defenders representing people at their bail hearings, and numerous other improvements that we've seen in the system. There's much work to be done. As Professor Garrett said, we've only just started. We're 1.5 years into this 7-year monitorship, and many of the projects that Harris County has agreed to take on are longer term projects that we will continue to see the progress and the improvement. It's an enormous job to turn this system around. This is the 4th largest city in the country, enormous county with many thousands and thousands of people that go through the courts every year. But we're pleased with the initial progress that we're seeing. And to tell you more about the data and the analysis that we've been doing, I'll turn it back over to Professor Garrett.
Thank you so much, Sandy. So I'm Brandon. I teach at Duke Law School. I wanted to summarize what bail reform means in the context of this consent decree, because people use the term, even just the word bail broadly, and certainly talk about bail reform to mean a lot of different things. And there have been a lot of different approaches towards changing or reconsidering the pretrial system over time in Harris County, in Texas, and in different jurisdictions around the country. So there's a reason why people can be confused about these concepts, because they really do mean different things, and there really are different procedures in different places. Often when people think about bail, they're thinking about whether the person is in jail or not, but it's much more complicated than that. And in particular, under the old system for misdemeanor bail in Harris County, which is what our focus is, we were only studying and supervising the implementation of a misdemeanor bail reform decree. So only cases, misdemeanors being cases where any potential detention would be for less than a year. They tend to be lower level criminal arrests. So under the system that was in place during the litigation and prior to the O'Donnell litigation, if a person was arrested on a misdemeanor, they would tend to have imposed a secured money bond, meaning that they could absolutely be released from the jail. They would not necessarily end up in the jail, but to obtain that release, they had to put up money up front, which is the sort of the secured part of it. They might get a loan from a bondsperson in order to come up with that money if they didn't have it themselves. They would borrow the money and they would have to pay a fee, often a 10% fee. If a person didn't have the money to pay that amount themselves, or if they didn't have the money to pay the fee to get the loan, then they could end up in the jail, and many people did. And so that was what the lawsuit was about, that poor people were ending up in the jail, not because they posed some kind of public safety or flight risk, but because they were too poor to pay dollar amounts in these misdemeanor cases. Now, the misdemeanor bail reform in the O'Donnell consent decree isn't a reform that means that everyone gets out in misdemeanors. Instead, there are several aspects of the architecture of this consent decree. Before this case was resolved in a consent decree in November 2019, the judges in Harris County, criminal court, the CCCL judges, agreed that a different rule was needed, and they adopted a rule called Rule 9 in February 2019, which described a series of changes in terms of how misdemeanor bail hearings would be conducted. And broadly speaking, what the new rules are, and they're incorporated into this consent decree, is that if a person is arrested of most types of misdemeanor offenses, that person is released on what is called a general order bond. And that means that the person is booked, their information is taken down, and they will be told when it's time to come to court for their case, and then they are released. So most people are released promptly without a hearing. However, for more serious misdemeanors, there are 6 categories of these, and they include repeat DWIs, family violence, and terroristic assault arrests, prior bond violations, parole violations, outstanding warrants. For those types of misdemeanor cases, arrestees are not automatically released, and instead they get a bail hearing. However, that bail hearing is different than those that occurred in the past before this consent decree was entered. So before this consent decree, apart from a small pilot program, which did expand over the years, but most people did not have a public defender, and the hearings were very, very brief. When you watch videos of hearings before the O'Donnell consent decree, there might be 30-second hearings because the magistrate was following a bail schedule. They would ask, what were you arrested for? And they would look down the schedule and say, oh, that's a $3,000 bond. It didn't matter what your circumstances were, what your ability to pay was. And so instead today, there's a much more robust hearing. There's a public defender there to explain what the person's situation is. That public defender has discovery and information about the person's criminal history, about the person's finances, and has an opportunity to prepare for the hearing and meet with the client and discuss what the options are and explain what the consequences are of different decisions that the magistrate might make. We've been watching videos of these hearings and observing the magistrate's opinions. The hearings are they're not 30-second hearings. The hearings are 5, even 10 minutes. There's a substantive discussion now of what is the best approach, and is there clear and convincing evidence that this person needs to be detained for a public safety or flight reason, or not. And if the person is released, it's not just an in or out decision. If the person is released, are there conditions that are appropriate to ensure public safety? Are there conditions associated with that release that can better protect the public and also support the success of the person? And so this consent decree includes a number of different provisions. It also includes not just reforms focused on that bail hearing, like the public defense representation, discovery, the due process protections, like a clear and convincing evidence standard. But there are other supports in place under this consent decree to help to ensure success for the people who are released and not detained in the jail. One way that this consent decree creates a better architecture for success after that initial bail hearing is that there's a right to appeal the next business day and have a judge look at what the hearing officer did. And if there's a question about whether the hearing officer's decision is well supported or not, there's a chance to have that reviewed right away. So the person isn't going to languish in the jail for days and days and days without an opportunity to have a judge look at what the hearing officer did. Longer term, one reason why people can get rearrested after their initial arrest in a case is that they don't appear in court. There's a failure to appear entered. Bond can be failed for not showing up in court. But in the past, the rules for what counted as a failure to appear were not always clear, and there are differences between judges and how they applied those rules or how they interpreted them. Under this consent decree, there is a clear set of rules on court appearance in misdemeanor cases and on what appearances are required where the person must be there, and what appearances are those where the person doesn't need to be there and their lawyer can handle it or it can be rescheduled. There are also provisions in this consent decree designed to make it more feasible for people to reschedule court appearances where it's not that they want to willfully escape justice, but they can't miss work, or they have to take care of an ill relative, or they themselves are hospitalized. There's a system in place now to electronically reschedule court appearances. There is a new court appearance system that was put in place last November, implementing these new rules, but some of the electronic aspects are still being implemented, which is one reason Sandy said, look, some of the aspects of this consent decree, which are really important, are still in progress. So although Rule 9 and the rule that for certain misdemeanors you are released at the point of booking, for others you get a bail hearing with a public defender, that dates back to February 2019. The system of electronic court notifications, though, with supports in terms of people coming back into court, knowing what their court date is, what the options are, can you reschedule, or do you absolutely need to be there? That system is going to be implemented very shortly on November 1st, and there's been an enormous amount of hard work that Universal Services and the Office of Courts Management in Harris County has done to build this electronic court notification system. We all can get great notifications depending on who our doctor is for our doctor's appointments. Court hasn't always been that way, and Harris County is going to be a model once the system comes online in just a few days, which is really exciting. But that major pillar of the architecture of this consent decree has been in progress for many months now. It has not yet been implemented. Very soon. There are also aspects of this consent decree that have to do with sound holistic defense. Having people accused of misdemeanors get a lawyer that communicates with them well and thinks about the right options for that person, advises them, and represents them in a sound way. There's a major report produced this summer on that topic and making recommendations on improving the quality of misdemeanor offense, both at the bail hearings, but mostly focused on misdemeanor defense after the bail hearing as cases proceed to the merits. So that's why this is a 7-year project. There are aspects of this which didn't instantly take effect when this consent decree was signed. And for some of these improvements, like the court notifications, which the electronic court notification system is just being implemented as we speak, and it may be many months or another year before we really start to see the impacts of those improvements. Other improvements having to do with holistic defense or services to support legal defense are still very much being implemented, and we may not see improvements until farther down the road. and the Harris County and the parties that brought this case, when they designed this consent decree before Sandy and I and our team were involved, they anticipated that this would be a big undertaking, like Sandy was describing. That's why our term is for 7 years. We agreed to take on a 7-year project. It's a long time. Certainly much longer than the types of projects that we're used to as law professors, where we teach students. We teach students for a 13-week course, not a 7-year undertaking. We also wanted to share our findings. In terms of major accomplishments to date, I've mentioned a few of these already, and so has Sandy. It was very important to us that the misdemeanor system be accessible, and a whole series of court forms have now been translated. We are, very close to full implementation of the text notification systems that people on their, whether it's email or whatever kind of device they have, if they have devices, they can get notifications of court dates. As I mentioned, that's scheduled to be completed by November 1st. There was a lot of thought, and we're really grateful to the criminal court judges and the hearing officers for their deliberations over this. A lot of thought put into the misdemeanor pretrial hearing forms that are used to record information about what happens at a bail hearing. In the past, it wasn't clear or easy for a hearing officer to record whether a person was indigent or not, which is a key distinction in this consent decree. People who are indigent, aren't supposed to be assessed financial costs, for example, but there was no way to record that information on the old form. There wasn't a clear way to report the kind of factual findings that are needed to show that you have clear and convincing evidence that there's a public safety concern and a person should be detained. It's much more streamlined. There's also work under this consent decree to assess how things are going. And so we'll be getting a report later this fall from an outside vendor that has been looking at, why do people not appear in court in misdemeanor cases? What are the causes? Is it lack of transportation? Is it that people forget about their misdemeanor cases? Is it that people are afraid to go to the courthouse? Is it medical reasons? Are there explanations for non-appearance that we can do something about? There may be others that are more challenging and harder to do something about. But the goal is to learn in an ongoing way about how to improve the process. There's also been training provided to a whole host of stakeholders, including public defenders, district attorneys, hearing officers, judges, other county officials. We've been getting feedback on those trainings and in response providing feedback to the trainers as that process has proceeded. And like I mentioned, there's also been this lengthy and detailed assessment of misdemeanor indigent defense and its strengths and weaknesses. That substantial report, we sort of summarized it in ours, but it's a impressive document and has a whole host of observations and recommendations. In terms of what we have found, in addition to providing feedback on the implementation of all these pillars of this complicated consent decree, in general, what we have been observing over the last year and a half, but we have data going back to 2015 that the county has shared with us. Mostly it's data from the court, from the district court. And so, it's public record type data about how many people are charged with misdemeanors and then what happens in those cases. Do people plead guilty? Are they detained on a secured bond or an unsecured bond early on? And then as their case proceeds, are they detained? Do they comply with their pretrial conditions? What kind of sentence is imposed? Are they rearrested for some subsequent conduct? In general, what we're observing is a steadily shrinking misdemeanor system in Harris County. So there are just fewer misdemeanor cases in each year. We see a steady decline. There may be more than one reason for that decline. We can't say whether it's the main explanation is that less people are committing misdemeanor offenses, or it may also be that there is some discretion being exercised not to charge people with misdemeanors. We know that there have been some arrest stage diversion programs, for example, concerning marijuana offenses. And so some of the decline may be less conduct, some of it may be discretion among arresting officers and prosecutors. But either way, we certainly observe a notable downward trend in the number of misdemeanor cases. We also, accompanying that, see fewer people who are rearrested after their initial misdemeanor arrest for some follow-up offense. Very few misdemeanor arrestees are rearrested for a serious offense, although it certainly happens. Most people arrested for misdemeanor offenses experience a relatively short period of pretrial detention, and so that's really changed. In general, before these misdemeanor reforms, people tend to be held on secured bond, and now most people are not held on secured bond. We also note that in terms of the race and ethnic makeup of misdemeanor arrestees, those both as to race and ethnicity, there has been very little change. There has been a modest increase in the number of people arrested for misdemeanors who are identified as Latinx. In general, the percent arrested for misdemeanors who are Black has stayed steady, but certainly exceeds the share of the Harris County population. And so what the source is of that race disparity is important. It's something that we'd like to understand better. And we don't have the kind of data right now that will allow us to conclude whether it is about arrest rates or discretion of officers or something else. We also want to note that there's been a great decline in the number of misdemeanor arrests that turn into a conviction. And so we tend to think that in the criminal system in general, people who are arrested are not, and I'll describe that a little more in a moment. Again, we continue to see a shrinking misdemeanor system. There was certainly a noticeable decline in 2020, but this isn't just a pandemic decline in misdemeanor arrests. There's been a steady decline in misdemeanor arrests for years now. We know that it was about over 60,000 misdemeanor arrests in Harris County per year in 2015. Now it's closer to 4,500, so like maybe a decline of 15,000 or so arrests, which is a big change. The bond amounts have also really changed. It was really common to see multi-$1,000 secured bond, even in misdemeanor cases, back in the days before these bond reforms, the O'Donnell consent decree, were entered. Now it's much less common for there to be any kind of secured bond at all. And even when secured bond is imposed, it tends to be for a more modest amount. We don't have great information about bond failure rates, including for the reason that I mentioned, that in the past it wasn't, there weren't uniform decision-making criteria for bond failure. Now there's a clear set of rules under this consent decree, the set of court appearance rules that I mentioned. We will be getting data before too long, looking at what it looks like under these new court appearance rules. They're new, and so there hasn't been much to study yet. We do note that what data does exist sort of before the adoption of these new court appearance rules suggests that there was a real decline in bond failure rates. It rose a lot between 2015 and 2018, and it has gradually declined since then. For whatever reason, more judges were failing bonds before these bail reforms, and it could have been the discretion of the judges involved, or it could be that bond failures have genuinely declined in the years since. We don't know, but what we do know is that there hasn't been any documented change in the time period between when bond, was sort of up to the judges, and then when the O'Donnell consent decree was entered. But again, all of this data before 2021 is subject to important limitations. On the topic of repeat arrests, the share of people arrested for misdemeanors who then had another arrest, or maybe more than one additional arrest, that the share of people who have had that happen, who have had repeat case filings, repeat arrests, that those shares have remained largely constant since 2015. It's also just many fewer numbers of people who are coming back into the system because there are just fewer misdemeanor cases filed every year. Again, we've seen this steady decline in misdemeanor filings each year. So just in general, big picture, Did the rule change? Did the O'Donnell consent decree cause some kind of a crime crisis of some kind? Is there more criminality? No, the level of offending or reoffending is not higher, it's lower. We note that if you just focus on people who are on bond, it would give the impression that criminality is up, which is not true. The reason why is that before the Rule 9 change, very few people were out on bond. Instead, in the days before Rule 9 and before the O'Donnell consent decree, people tended to have a secured bond, like I mentioned. They couldn't pay it, and they would plead guilty to get out of the jail. And so you had large numbers of people who were in the jail for very few days, but they would be in the jail and they would plead guilty to end their case. They would then get rearrested, but they were not on bond. They had pleaded guilty. And that also connects to one final aspect of our findings that we wanted to share. In terms of case dispositions, the share of misdemeanor cases resulting in a conviction has rapidly declined over the past several years. And so, most of these cases do not any longer result in a conviction, and most do not result in a guilty plea either. Far more of these cases are outright dismissed, maybe not right away, and the length that a case is on the docket has increased. The share of cases that is disposed of within a year has fallen over time. So, back in 2015, some cases were disposed of within a year. Some cases were disposed of within days because a person pleaded guilty in the jail. The share has fallen to 43% during the first half of 2020. So the length of time a case remains open has increased recently. And that said, there are larger reasons why there are new sources of delay in the misdemeanor dockets. The system never fully recovered from Hurricane Harvey and the court closures that resulted from that natural disaster. And COVID, the pandemic, resulted in closed courtrooms, and took quite a bit of time for trials to resume. They have now resumed, but during that time in which court operations were disrupted, the backlogs increased. So we do note in our report that in misdemeanor cases, you see fewer cases in which there is a guilty plea or a diversion or some other outcome. A growing share of the cases, it was up to 68% of cases in the first half of 2020, are cases where the misdemeanor charges are ultimately dismissed, but maybe after some period of time. So hopefully that gives a good overview. We just want to end by highlighting that it's important to take a long view of these trends. For example, we'll know a lot more about court appearance under the misdemeanor reforms instituted under the consent decree after these new electronic notifications are in place, because the court appearance system is designed to work with electronic notifications. So you're told about your court date and you have options for rescheduling sometimes, and other times it's required and you don't have a chance to reschedule, you need to be there. We also plan to report on more detailed information about both the demographics and aspects of the vulnerable populations who are arrested and rearrested in misdemeanor cases in Harris County. There are other aspects of the system which are also recent and where we want to make observations and assess how things are going. But in general, we want to also leave you with the understanding that important changes have already been made. And to the extent we're seeing trends over time, what we're seeing is a shrinking misdemeanor system, fewer misdemeanor filings and fewer people coming back into the system. And that's not to say there aren't real public safety concerns certainly with some misdemeanor offenses and some people who are rearrested and come back in serious cases. And there are public safety focused improvements that can no doubt be made to the system. But overall, what we have seen is an enormous amount of hard work implementing the pieces that have been implemented so far, and hard work towards implementation of the remaining pillars of this consent decree, and an enormous body of really positive evidence concerning how this consent decree has fared in its first almost 2 years of operation. So thank you again for this opportunity to share with you all, and we really, really look forward to your feedback in the Q&A and the chat. Thank you.
So much, Professor Garrett and Professor Thompson. We really appreciate your overview and your monitorship for the consent decree. Next up, we have Rachel Frazier, an assistant county attorney in Christian Menifee's office. And so she'll share from her aspect what they've done and to contribute to all of the changes of the consent decree.
Hi, thank you, Bree. Thank you, Brendan and Sandra. So my name is Rachel Frazier, and I am here on behalf of Christian Menifee, the Harris County Attorney. So at the county attorney's office, we're working with the stakeholders to ensure a constitutional and transparent system. We're working to safeguard arrestees' rights and to ensure public safety, as well as systematic transparency. The county attorney's office continues to provide legal advice, consultation, and contract management in ongoing decree obligations, including revising court and pretrial forms that Brandon spoke about, ongoing training, updating text and other notification systems, and data reporting and distribution. We will continue to work with the stakeholders to study court non-appearance, to continue implementing electronic notification and scheduling options, and on ongoing training, as well as advising on data dissemination. At the county attorney's office, we meet regularly with the monitor and working groups and continue to represent Harris County and work towards the effective and enduring policy implementation of the O'Donnell consent decree with the ultimate goal of improving justice. Thank you.
Thank you so much, Rachel. Next up, we will have the Harris County Sheriff's Office representatives talking about their aspect of the consent decree and what their roles are. Major Doherty? It appears that the Sheriff's Office might be having some connectivity issues. All right, well, once they're back connected, we'll try to get them back online so they can share their aspect of the consent decree implementation. We'll go on to the Criminal Courts at Law presiding judge, Judge Toria J. Finch.
Greetings, everyone. It's a pleasure to be here. I am Judge Toria Finch, the presiding judge for the County Criminal Courts at Law here in Harris County. For those that do not know, there are a total of 16 county criminal courts at law. And, you know, I'm proud to actually state to each of you that bail reform, misdemeanor bail reform has been successful. And it's been successful due to the hard work of all of the county partners and stakeholders, the monitors, and even community leaders and advocates, our county criminal court judges, and I would dare not leave out our Office of Court Management. You've heard a lot of information, so I kind of want to take a step back just a little bit. When we talk about bail reform, as Brendan spoke about already, we have to understand we're only talking about misdemeanor cases, okay, not felony cases. Misdemeanor cases in our county criminal courts at law simply say that our jurisdiction cannot exceed more than 1 year in the Harris County Jail, and the fine cannot exceed more than $4,000. So we're talking about cases like failure to ID, evading arrest, theft, driving while intoxicated, assault family member cases, those kinds of cases. I know many times it kind of gets conflated when we listen to, you know, different sources about bond and bail, and we hear about aggravated robberies and murders. Those are not misdemeanor cases, and that's not what we're really talking about here today. When we talk about bail reform, again, we're talking about misdemeanor cases. Because of the federal consent decree, as you've heard from our other speakers, misdemeanor bail reform has been successful. We've already heard that pretrial detentions have significantly decreased. Recidivism has not increased. I must say that again, that recidivism as a result of misdemeanor bail reform has not increased. Also importantly, racial disparities in pretrial release decisions have significantly diminished. Harris County has experienced significant cost savings due to fewer misdemeanor pretrial detentions. And all of this has been done without compromising the safety of Harris County. What we know, and I'm going to take another step back, is that the law in the Texas Constitution has what we call the Bill of Rights. Article 1 is the Bill of Rights within the Texas Constitution, specifically Section 11. We're going to have a mini law class here because I know a lot of people are really confused about what bail means and why don't we keep everyone locked up, okay? We can't do that. Let's start there, right? Because the Bill of Rights requires in the Section 11 that everyone is entitled to a reasonable and fair bond, except for cases that are violating a protective order involving family violence. In misdemeanor cases, that's the only scenario where we could even hold someone at a zero bond or deny them a bond. And then there's still steps that must take place, okay? Even if we have that type of offense in front of us, which would be your family violence cases, right? There still has to be a motion in a hearing, and the judge must make a finding by preponderance of the evidence that the offense actually, there's concern for the safety or that it actually occurred. But the reason I bring that up is because since the Constitution requires that we as judges have a bond for people, what we know from our studies is that money bonds don't make our community safer, right? And it doesn't make our system better. We know that because for far too long, the unconstitutional bail practices have caused people to plead to offenses that they didn't do solely just to get out of jail to secure the safety of their lives, their children's, their home, their well-being, and things of that nature versus being in the freedom or in the community to be able to defend their cases like their counterparts that may have already had the money. But here's the reality. In what we do with misdemeanor bail reform, we are constantly balancing the importance of complying with the law and public safety. Our judges never set aside public safety because you also have to remember that we're members of the public too. We go to the same grocery stores and the same malls and the same places you do, and we want to live in a safe community just like you do, but we have to make sure that we are making sound, safe decisions and following the law. Well, how do we do that? Well, the consent decree requires that we have individualized hearings where both parties, meaning the defense and the state, are present with the person that's accused of committing an offense, and we receive evidence and we learn from the attorneys as to the nature of allegations. We give the state an opportunity to present information that the court should consider in making that bail decision. We hear from the defense attorney and sometimes the defendant as well, and sometimes even complainants of offenses. And after hearing that information, the judges make decisions that we believe that are best, and we will acknowledge there's no science to it, right? But what we know is that there are ways to make sure that we can keep the community safe and not jeopardize or sacrifice the constitutional protections of accused individuals. And we do that by assessing non-financial conditions of bond that are customized for that person. It could include monitors. It could include some kind of alcohol detection device. It could include random urinalysis. It could include so many different tools that we use to ensure that the community is safe and that we're able to properly supervise someone. So what is the path forward, right? We've heard from our experts. We see and know from the studies that misdemeanor bail reform is working. It's not compromising the safety of our community. But how do we go forward from here? Everyone agrees that we are in the infancy stages of our misdemeanor bail reform. So what we continue to do is work with our stakeholders, work with our community leaders, our monitors, and everyone to ensure that we study the progress of misdemeanor bail reform, and that we begin to target the areas of concern where there are recidivism issues, where if someone repeats an offense or comes back for a second offense. We look at how can we target that to eradicate that issue. We're constantly studying it because we want to make sure that we are putting forth the best measures possible. Another thing that we're doing, we recently received our new pretrial service director, who we've met with and we're working with to try to staff court pretrial service officers in each court. That person's role will be to help the judges in supervising the individuals that are in the community on bond, to make sure that compliance is there, to make sure that the appropriate conditions are there, and to ultimately ensure that the community is safe. What we're also doing is making sure that we work with our stakeholders to eradicate the case backlog issues that have occurred because of the court system being shut down due to Harvey, also as well as the COVID-19 pandemic. That's important to us too. Why is that important? Because if we don't move our system along, we have people out on bond much longer than what we would prefer to, right? And that means that we're not able to provide all of the resources that the county has available towards treatment and rehabilitation and other things and tools that we can give people to help them with their lives, and also help victims of offenses and help keep our community safe. So we're constantly working to move our system much faster so that we can move our cases to disposition. Some other things that we've come up with that we're working with is the Managed Assigned Counsel program. You've heard from some of our other speakers that we have created a program where now we have a separate division from the court that will essentially be responsible for, and we call them the MAC. So if you hear that, it's called the Managed Assigned Counsel. And their office is solely established to do the court appointments, right? There was a time when judges would appoint attorneys for indigent individuals. Well, we believe there is an inherent conflict in doing so, right? We don't pick the prosecutor, so it's not right for us to also pick the attorneys for the defendants as well. So we have a separate body that is responsible for ensuring that certified and qualified and competent attorneys that are on the appointment list are appointed to indigent defendants. In addition, that office will staff with those attorneys in a holistic type of approach, providing resources and social workers and caseworkers and all these different tools that will help also in ensuring that we have effective representation as well. We've created the Cite and Release program. The Cite and Release program is a program that allows officers to make that decision on certain agreed upon offenses to simply cite someone versus arresting everyone and bringing them into our processing center, basically bringing them into custody. We've also created an open hours court. An open hours court is important. I'm just kind of hitting the highlights of things because we've done so many things. I don't want to take up too much of your time, but I think they're important for you to know. We have an open hours court. Why is that important? Because we understand that many people that are on bond, especially due to the extent of time that they're on bond, they may miss a court date. And so we want to give people an opportunity to not flee from justice, but to run to the courts or come to the courts when they've been properly notified that they've missed a court date. Because we understand that when police officers are executing warrants, that can be the most dangerous aspects of their job. And if we can reduce that by giving people the opportunity to turn themselves in and not run in fear, that in and of itself makes our community safer, and it protects our officers that are on the front lines. You've heard other panelists talk about how we've taken huge steps in improving the notification systems to make sure that people know when to show up for court, okay? Because when people don't show up, it's another way of the system not moving efficiently. And so we make sure that they have opportunities of receiving emails and text messaging, and other things are in the works to make sure that everyone has an opportunity to be informed of when their court date is, where to appear, and what's happening on their cases. And just ultimately, moving forward, we will continue to embrace our community partnerships, our county stakeholder partnerships, and anyone else that's willing to work with us to make sure that we're doing this right. Again, the judges care about following the law, and we also care about people that have been adversely affected by the offenses that have occurred, unfortunately, in the system, and public safety ultimately. So our goal is to perfect this as much as possible. And so we thank you for being here to learn more about the misdemeanor bail reform. But if you don't take anything else away from this, I want you to hear and know from me that it is working. And it is not causing our community to be unsafe. If it did so, we would not do it. And so again, I thank you all for being here. I look forward to receiving your questions and responding accordingly.
Thank you so much, Judge Finch. And I would like to thank all the panelists again for your input and all of and being in compliance and making sure that we are doing our just doing everything in our power to make sure that the public is safe and that we are in compliance with the consent decree. And so throughout the presentation, you all have had the opportunity to put questions and answers in the little chat box. And so we haven't received that many yet. So if you still have some questions that are burning in the back of your head, feel free to put them in the Q&A section now so we can answer them. So Brandon, there was a question about a clarification on the race and ethnicity of those that are being arrested currently. So it did show that there was 40% white and 60% African American. And so they wanted to know if that was on a 100% scale or exactly how did the Latinx fit in there?
Yeah, so race and ethnicity are recorded separately following the census designations in Harris County. And so that means that 100% are either denoted as Black or white in the data. And then we separately did analysis to examine how many of the people who are either denoted as Black or white share a Latinx ethnicity. And so that's the reason why there are 40% Latinx persons, and nevertheless, there's the breakdown of 60% designated as white and 40% designated as Black. We describe in the report that we had to do some analysis to impute Latinx representation because that's a field that's not always recorded when people are booked. So we did some work over time to produce a good estimate.
Thank you so much. So our next question is, are family violence defendants appearing in person to get a MOEP?
I'll take that question if it's okay, Brianna.
Yes, please.
And just to make sure I understood the question, are family violence defendants appearing to receive the MOEPs? Okay, just for those that are out there, that is legal jargon that we use when we say MOEP and MOEP. That stands for a magistrate's order for emergency protection. It is a protective order that typically is filed in our family violence cases, both on the misdemeanor and felony side of it. And essentially, it has some prohibitions in there where a defendant is not allowed to possess a firearm. They cannot go within a certain distance from a residence of a complainant, their place of work, their child's daycare. They're not allowed to have threatening or harassing or assaultive contact, and it goes on and on. And traditionally, it's only in place for a period of 61 days, and it has certain punishments if it is violated, such as a fine that cannot exceed more than $4,000, possibly a new charge of violating a protective order, and so forth. So just give you a little background on what that is. Yes, they do come in to do those. Many times those protective orders, though, are done on the front end when they appear before a hearing officer. So if they, for whatever reason, received what we call a general order bond, where they qualify for just kind of a fast track out because it was like a theft case or a failure to ID offense, and they come to court, then we will do it at that point in time. But typically, those protective orders are initiated by the state of Texas through the DA's office, the district attorney's office. But yes, when those are brought to the court, the defendants are there, properly admonished by the court, and then they sign the protective order with the clerk.
Thank you, Judge Finch. And I think we have another question that you would be great at answering. You can let me know if it needs to be directed elsewhere. But it was asked is, the community needs to engage with our court systems much better to eliminate ordinary injustices, such as blind spots in the courtroom. How do community members help courts continue the great path it sounds like you're on?
Excellent question. Thank you for your question. We agree that we have to bridge that gap between the courts and the community. In fact, we are working on a program called the Bridges Program, which is not quite yet off the ground, but we do see that need. One thing that I can tell you is that all of our county criminal courts do live stream. And so if you ever want to see what's happening in your court, in your courts, because they are your courts, we just sit on the benches that you elected us for, you can simply, from the comfort of your home, log into our courts. And I believe if you Google Harris County live stream, it will take you to the link, and then you'll see county criminal courts. Hit that link, It'll give you all the courts. You click watch and you can watch any of the 16 courts that you desire to see. So you don't have to take word of mouth. You can see for yourself. Other things that I would suggest too, if you decide to come to the course, or you can email the course, we are always open to feedback as to what you believe we can do better. You can contact our Office of Court Management as well. You can Google that, it's on our county website, but we are open to receiving feedback from our community because we are public servants and we want to make sure that we address the needs of the public.
Yes, and that goes into the next question as well. Are courts open to come down and observe? And yes, they are. But additionally, as Judge Finch just noted, you can see all of the courts online that are utilizing the Zoom feature as well. So you can come and see them for yourselves or watch them at the comfort of your home.
And so everyone knows we are open Monday through Friday. Okay, so feel free to come through.
Great questions. There's no more in the chat right now, but we'll give it a few more minutes and allow any other questions that anyone has to put in the chat. We would love to answer them for you today. Yes, we can repeat the site one more time. It was harriscountylivestreamsjudge.com.
Absolutely. Here's the exact link. I have it up on my computer now. Okay, so if you go to, just closed it out, ccl.h as in Harris, C for county, TX for Texas, .net, N-E-T, the / court stream.html. It'll take you right to it, but also if you just Google or Bing Harris County Court live stream, it'll come up for you as well.
Thank you. Who can the public contact when the live stream isn't available?
The courts. If you go to our Harris County Criminal, let me give you that link as well, because we have a website that has our Office of Court Management information on there. And I'll read this one slowly as well. Let's see here. The link with all of the contact information for the Harris County Criminal Courts is still the ccl.h for Harris, C County, TX for Texas, .net / criminal, which is CRIMINAL / default.htm. That'll take you to the main page, but it's always easy just to Google Harris County Criminal Courts at Law and it'll pop up. You'll see that it lists all of the courts. You click on the link, you can have a phone number and an email, and we will be able to receive that information from you.
So the next question is, so the courts have no COVID guidelines, which we do. There are guidelines, COVID guidelines for the courts, but it was asking, they are at full capacity. So if someone wanted to come and observe, they would not be turned away due to the capacity limits?
Great question. We're currently at a 50% capacity. And so if you come, the courts are open to the public, right? And so if you've come through, they will ask you those protocol questions. They'll take your temperature. Have you been exposed to someone? So we do have a COVID safety plan in place through the county and individual courts. You'll make it to the courtroom. I don't see anyone turning you around, but they do monitor the occupancy levels to ensure that we are in compliance. But worst case scenario, if you're there, you can let the deputy know that you're there to observe. And if it is full, as people exit, you can come in, but we will make a way for you to visit your court. We won't just turn you around.
Next one. Article 17 is such an important section within the Texas CCP. With the way Harris County is operating in its misdemeanor courts now, and has it also seen a dramatic reduction in Article 17-151 bail hearings?
Mm-hmm. Is that for me?
Mm-hmm. Has it also seen a dramatic reduction in Article 17-151 bail hearings?
It's, yeah, specifically talking about bail hearings. I don't know what the statistics are on that. I'll have to probably pass that on to Brandon and Sandra. Do you have the numbers for that?
I mean, in general, yes. So there's a much higher share of cases. Well, two things have happened. Like I described, there are just fewer misdemeanor cases. And so there are just fewer misdemeanor arrests every year. And but number two, once the Rule 9, the O'Donnell consent decree took effect, there's a big chunk of misdemeanor arrests which don't have a bail hearing because the person is released on a general order bond. And so there's a fair number of cases that fall into those lower level misdemeanors where there's no hearing. And so what that means is there are fewer cases, and there are fewer cases where you need to have a bail hearing. The bail hearings, however, don't last 30 seconds or a minute anymore. There's more to do in a bail hearing if there's a public defender there. What the idea is that there's time to much more seriously and rigorously consider the issues in the cases that raise greater public safety concerns, like the domestic violence cases involving protective orders that Judge Finch was discussing, for example. You don't just sort of say, no protective order, yes protective order, right? You need to have a serious discussion about whether there's a threat to a victim's safety in a domestic violence case. And so, the overall goal of the judges and then the parties that developed this misdemeanor bail system was to build in more time to seriously consider the evidence and the options in the serious cases. And so I guess I would say there are many fewer bail hearings, but it takes more minutes, it takes more time to seriously work through the issues when you're not just following sort of a schedule saying, oh, you're arrested for X crime, $3,000, B crime, $2,000, right? And so it really is it's a time commitment to adopt a system like the one today, where these findings need to be made on the record in this more rigorous way.
All right.
And if I can add to what Brandon was, I'm so sorry. Just to add to that, even when we have the hearings, because they are time consuming, if we don't have enough information, sometimes we will continue that hearing, right? To gather the information that we need to make the right decisions. This is not, just a roll of the dice. This is something that we take very seriously. We take our time and examine the information to make sure that we're making the best decision.
So the next question is, will there be another public hearing? Yes. So there will be public hearings semi-annually. So it will be every October and every April. And so the next one will be in April. And so depending on how the pandemic is going, that one may be in person at 2 separate locations. And so as always, we ask that you sign up for the Justice Administration emails and newsletters. And so all of that information comes through there. At the end of the presentation, we'll give you what our website is, where you can sign up to get further information, so you can get all the information about what's going on in the criminal justice system in Harris County, and then also so you can know about the public meetings and the progress of O'Donnell and several other initiatives that we have going on. The next question is the public allowed to observe the magistrates?
What I can say about that is the area where they have them, it's so small in size that it virtually makes it impossible for the public to come in, because you have a series of defendants that might be coming in to be processed. The hearings it's a very small hearing. It's not set up like your traditional courtrooms, but they're not in any way secret or private. It's just that logistically it's challenging to have that happen.
May I add about the magistrates? We do have a viewing room on site in the JPC. It's up on the second floor lobby. It's open to the public. It's open to the press. It's very small, but it broadcasts every single court appearance that's done inside the JPC in front of the magistrates.
All right, we've had some fabulous questions thus far. We'll give it a few more minutes. You all received a compliment. Judge Finch and team of panelists, I'm impressed by the presentation and oversight applied to the misdemeanor bail reform. I'm really satisfied with the magistration bail hearings having an attorney present at all pretrial defendants who are booked. With all this going, what are a few ways you believe adequate counsel is being provided against the inadequate ways we've known? Anything distinctive?
The managed assigned, well, first and foremost, thank you so much for your feedback. We really appreciate it. The main difference would be the managed assigned counsel program. So, we do have a public defender's office, and we have the new office of the managed assigned counsel, which is headed by our executive director, Kenneth Harden. And so they are working really diligently to ensure that the qualifications to be on the list in the first place are where they need to be and meet industry standards. Additionally, they provide COEs which are continuing legal education programs. They have mentorship programs. They have all kinds of resources that we did not have before for our court-appointed bar that we do have now. We have an amazing defense bar, no doubt, not taking any credit away from them. But what we've added with the managed assigned counsel is an additional benefit to allowing them to be even more effective than what they were before. So that would be the primary difference between what we had back then and what we have now. And also that includes, I forgot to say, investigators, and we have interpreters. We have all kinds of resources that we did not always have readily available from the courts, although the public defender's office was very helpful in sharing their resources with the appointed bar.
I would also highlight, like there aren't that many hours between the time that someone is booked and a bail hearing. Bail hearings are conducted promptly, which is the right thing to do under Texas law, and it's the right thing to do in general. But when people do fall in the carve-out cases where they're not released on a general order bond, the public defenders are on site and meeting with people before the hearing, so there's time to prepare, there's space to meet, and they're receiving electronic discovery. I'm not sure there are many places in the country where there's electronic discovery shared with defense lawyers prior to a bail hearing. There are plenty of places where there's no electronic discovery in criminal cases, period. And so, the kind of financial information that you need as a public defender to understand, like, is my client homeless? Can they pay a bond? Like, what would be an unaffordable bond? Are they indigent? In which case fines shouldn't be assessed on them. They have no way to pay anything. And the criminal history information that you need to know, like, what will the hearing officer be looking at in terms of the person's priors? Is that the reason why this person is having a hearing? Is there a violation of a prior bond or a probation or something like that? So that kind of information is before the person, so the public defender can review that, have a conversation with the client, and talk about options. Now, after the bail hearing, public defenders don't then represent everyone who is charged with a misdemeanor. So they continue to represent some of those clients. Others are then represented by court-appointed attorneys. And that's why it's really important, what Judge Finch talked about, that there's now a managed appointed counsel role to provide guidance to the court-appointed lawyers, to provide training and policy and support. And that office is new as of this past year. It's a real sort of improvement in best practices to have something central to provide that kind of guidance and support to appointed attorneys, to improve the standard of representation. But because it's new, I'm not sure we can say that we're seeing effects of it, so far. And that's something that is going to be, hopefully resulting in improvements to the standard of practice in general over time. But like I mentioned, there was that report last summer making some recommendations, a whole series of recommendations and lots of observations about the state of the defense system. There's been a lot of thought and work put into, and will be put into in the future, to think about how to make the representation system better. I mean, the stereotype in general in this country has been that defense lawyers don't care as much about low-level cases because they're just misdemeanors, and that's not true in Harris County. The goal is to really handle these cases carefully and well, both from a public safety perspective and a fairness to defense perspective.
All right, and you all received some more praise. Thank you all so much. This is really good information. And so we only have a few minutes left. Major Doherty, was there anything else additional that you felt was vital or that you wanted to add to the conversation?
No, just that the Joint Processing Center of the Harris County Jail, we intake approximately 250 to 300 a day, and we release that many. The majority of misdemeanors do leave our jail and are not housed. That helps us because we're at 97% full right now. So a very small part of our population is misdemeanors. The majority of our population are violent felonies. So it does help us.
So it doesn't look like we're getting any more questions in. Before we close, are there any other final remarks from any of our panelists?
Well, I would just say thank you all again for participating and taking an interest in what we're doing, because we're really working hard. All the panelists and their representatives and so many people that aren't here that have made this successful. We're here to serve. If there are any kind of questions or feedback that you might have, feel free to reach out to the county criminal courts. And also I want to kind of highlight that our monitors do have a website. JAD has a website that contains the monitor reports, because those may come out faster than the public meeting. So information is disseminated and available to you, and we'll be happy to get that to you. But again, thank you so much for attending, and we look forward to continuing to serve.
Well, thank you all again for coming. Thank you to all of our panelists for presenting all of the information and highlighting all of the things that we're doing to be in compliance. And so thank you, Dr. Anna, to our monitors, Professor Garrett and Professor Thompson, to the Assistant County Attorney, Rachel Frazier, to Victoria Jimenez and Major Patrick Doherty, and Judge Finch. We all appreciate you all and your team. We have so many people internally that we need to thank: budget management, purchasing, Office of Court Management. There is a lot of people, Universal Services, a lot of people that is doing a lot of hard work and doing a lot of overtime to assure that we are in compliance with the consent decree and to assure that our safety and justice goals are being met. And so our final slide is all of the contact information. If you all would like to see those things highlighted, the consent decree, if you would like to see the past presentations, even this PowerPoint, all of that is available at our website. And so that is at jad.harriscounty.tx.gov. We have a Facebook page, a Twitter. The monitor is independent, so they have their own independent website as well. If you have any further questions or concerns about the event today, feel free to email events@jad.hctx.net. Also, earlier in the presentation, I mentioned that we have correspondence that go out pretty often. So if you would like to be a part of that mailing list, please email your name and email address to the events@jad.hctx.net, and we can be sure to get you on that mailing list so you can stay up to date on all of things Harris County and our criminal justice system. Thank you all so much for your time today. Thank you for helping us in the community, and we look forward to seeing you again in the next 6 months. You all have a wonderful afternoon.